And we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the February 3rd, 2021 sitting of the Massachusetts Appeals Court. My name is Justice Eric Nyman, and I'm sitting today with Justice Suk-Young Shin and Justice Sabita Singh. We have 6 cases for you today. Each side will have 15 minutes to make its argument and presentation, and appeals court rules apply, so there will be no rebuttal. Also, this case is being live streamed on YouTube. So calling the first case, it is Commonwealth versus Santos Medina, matter 2020 P0538. We will hear first from counsel for the appellant, Attorney Linson.
Thank you very much, Justice Nyman. May it please the court, my name is Bruce Linson. I represent Melissa Santos Medina. And this is an appeal from the denial of a motion to suppress heard before the trial court prior to the defendant's trial in this case. I submit that it's a fairly straightforward issue. What we have here, Judge, is Justice is a state police trooper who pulled over my client operating on 93 North after he saw her tires cross the road. He then spoke to her through the passenger window, observed a billow of smoke come out the passenger window, which he thought and detected to be burnt marijuana. Once that smoke cleared, he had conversations with Miss Santos Medina. She produced her license and a Dominican driver's license and a passport. And when the trooper inquired of her as to whether she was licensed in Massachusetts, she replied no. And he then indicated that he removed her from the vehicle in order to arrest her for operating without a license, and subsequent thereto, ultimately searched the vehicle and found some narcotics that she was charged with. So the primary issue is the lawfulness of the exit order.
So Attorney Linson, my understanding, I'm at page 11 of the transcript, the officer asked for a license, and my understanding is that your client, that she didn't have one. And when I look at the record appendix at page 17, the motion judge made a finding that the defendant said, I don't have a driver's license. And then it's my further understanding that when she did produce, she produced a Dominican ID and a passport, which had different spellings of her last name. So if my understanding is correct, why is that insufficient for an exit order to occur?
I questioned Trooper McSweeney on that very point, Judge, and he clarified to the court, and it's on the record, that he clarified that he only asked the defendant whether she had a Massachusetts license, to which she responded no. He then took her Dominican license, called into dispatch, and asked the dispatcher to confirm her Dominican license. He said, I have a Dominican license here, and I provided the transcript of his call into dispatch where he referred to the document as a Dominican license to check it and see if he had a Massachusetts license.
So are you saying that the judge's finding that your client said, I don't have a driver's license is clearly erroneous?
I believe so, yes. I further submit that the Commonwealth conceded during the argument that the defendant was lawfully allowed to drive in the Commonwealth of Massachusetts, and that the arrest or removal from the vehicle for the sole purpose of effectuating an arrest, and this is what he testified, to arrest her for driving without a license was invalid. That's why they don't make that argument in their briefs, and they never made that argument at all. They exclusively and solely rely on an argument based on reasonable suspicion of operating impaired for marijuana. So
But why isn't that sufficient?
So there's no case in the Commonwealth that says reasonable suspicion exists where there's an odor of burnt marijuana and a Mark Lane violation. Nothing even close.
It's not just an odor, it's a huge cloud of smoke. I mean, and the smoke is so thick that he can't see who's in the car for 30 seconds. And once he's able to see, she's the only person in the car. So you're saying at that point, you can't order her out of the car?
No. He only followed her for a short minute. He doesn't know who was in the car 5
And in
minutes
a
earlier.
short minute,
Where
there were two occasions where the car drifted over the lane.
True, but that doesn't mean someone's guilty of operating under the influence or there's reasonable suspicion. A Mark Lane violation is certainly, absolutely.
Okay, but if she's the only person in the car and there's a large amount of smoke in the car, he could certainly infer that she was smoking while she was driving, right?
He did not infer, and this is the problem with the Commonwealth's argument. They're asking the court and your honors to infer everything in this case and not look to what the trooper actually did in this case.
But
That's not the relevant inquiry, sorry.
Right, it's an objective standard, so isn't that correct? Isn't the Commonwealth correct that that's our analysis?
It is an objective standard based on what the police officer actually did in the case. So you still have to take into account what the officer's actions were, what he did, what he observed, what he testified to, and then determine whether that was reasonable under the circumstance.
Why is it not?
Need to accept, sorry.
No, but Judge Singh, please go ahead.
We don't need to accept his rationale for what he did, only his actual actions. Isn't that correct?
Correct. His actual actions, in which he did not ask her if she smoked marijuana, did not look for any marijuana, did not find any marijuana, did not find any apparatus to use to smoke marijuana, saw that her eyes were not glassy and bloodshot. She had no trouble communicating with the trooper. She was not disheveled. She did not lean on anything. She did not fumble for her license. We've all gone as lawyers, and I know some of you at least were trial court judges, have gone through the whole litany of troopers trained to detect people that are impaired. And this trooper testified that from the initial stop of the car all the way through through her removal, there was nothing that indicated any impairment to him. He did not find any impairment. Everything he found showed that she was in fact not impaired. So even if your honors think it was reasonable for her to be removed, that there was reasonable suspicion at the beginning, once you take into account all of his observations, any reasonable suspicion was certainly dissipated by the fact that she communicated quite clearly, was not confused by any of his questions, did not fumble her license, did not slur her words, was not bloodshot.
If instead the trooper had observed her holding an open bottle of beer, but she could respond to his questions, okay, you're saying there's no reasonable suspicion to order her out of the car?
To infer that she's been operating impaired?
When you're actively drinking or smoking marijuana while you're driving on a highway, you're saying there's no reasonable suspicion for an exit order?
So he didn't ask her if she was smoking or if she had just smoked.
It's a reasonable inference given the amount of smoke in the car.
Not necessarily. She could have just dropped somebody off that had smoked marijuana in her car right before she dropped them off at their house. She was giving them a ride home. Who knows? But
enough that it would take that the officer couldn't see inside the car, and it took 30 seconds for the smoke to dissipate to the point where he could see into the car. I suppose maybe the car is hermetically sealed and maybe someone had just lit a joint and left it in there and no one smoked it. But isn't it a more reasonable inference that someone was smoking and they were smoking immediately prior to the stop with that amount of smoke observed?
Not when the trooper testifies specifically that he did not detect an odor of marijuana coming from her person, did not observe her to be with any marijuana paraphernalia, did not have glassy bloodshot eyes. In response to Justice Shin's question before, whether you're holding a beer, does that mean you're intoxicated? No, that would be a separate offense, open container in a vehicle. But if then, while holding that beer, the operator confers, answers all the trooper's questions, does not slur his words, produces his license, registration, doesn't fumble anything, is nice, clean, calm, collected. There's and the trooper testifies that all of those observations I'm trained to make to determine whether they're impaired, and no, all those observations indicated to me that this person was not impaired. At that point, then it is not reasonable to
certainly an officer could order someone holding an open bottle of alcohol. Certainly they could order them out of the car for the purpose of doing sobriety assessment.
And so this is my third argument down the road. If you're going to say there's reasonable suspicion, if you're going to reject the fact that all these innocuous observations or these observations confirm in the officer's head that she's not impaired, if you still say then it's okay to remove her from the vehicle, where are the field sobriety tests? She's only the truth.
That's because she almost immediately affirmatively offered up her consent to search the car. So is the trooper supposed to then say, oh no, I'm going to do these assessments instead and not search her car?
Yes, because he's only allowed to detain her for the length of time to confirm or dispel the suspicion, which was the basis for her removal from the vehicle. She didn't just run over and say, I consent to the search of the car. That's not what happened. She was told to get out. She got out. He then led her to the back of the car, put her in between his cruiser and her car with his cruiser and lights going and everything like that. And he said, I'm going to search your car. And she said, okay. So no.
He said, is there anything illegal in your car that I should know of? Are you saying that was improper to ask that question?
Yes, he's doing a custodial interrogation of her now at that point without having justified his suspicion for detaining her. That suspicion needs to rise to probable cause for him to then go down another path and start an inquiry as to what is in the back of her car. So everything he started doing on that road was illegal without having justified his removal. There's suspicion of impaired operation sufficient to continue the detention and then do his follow-up things after that. Yes, it is incumbent upon him. And there's case law in my brief. Commonwealth versus Colbert, erratic driving, once stopped, any suspicion of impairment was dispelled. The exit order was not warranted. Okay, that's first. Commonwealth Hernandez, I provided that case in my appendix to the brief, justices, sorry. Commonwealth versus Cordero, a routine traffic stop must last not longer than necessary to effectuate the purpose of the stop. And the stop must end when the purpose of the stop is accomplished. So the purpose of the stop, if we're saying any officer can infer that she might be operating under the influence, that suspicion needs to be confirmed or dispelled prior to extenuating the stop. So that's the third argument. But I mean, I think my best argument is that the trooper here, in fact, testified that he did not look for any marijuana, that he did not believe she smoked marijuana, that he did not find any marijuana, that he did not ask her for any marijuana, that he did not think she was impaired in any way, shape, or form. So we have actual testimony from the police officer that he observed all these things and he did not detect any impairment whatsoever. But after detecting all these things, he then still has her removed from the vehicle. So the Commonwealth is trying to say, hey, any trooper could remove somebody from a vehicle based on a large cloud of smoke. The officer didn't tell how he knew it was marijuana smoke, that marijuana even impairs operation of a motor vehicle. He didn't testify that he knew in fact this to be marijuana. He said he believed it to be marijuana, but he didn't testify that marijuana impairs operation. I'm trained to detect marijuana, and that I believe marijuana could in fact impair somebody's operation, and that's why I removed her. If he said that, we would be in a much different situation. But that's not what he said.
I know this isn't in the briefs, but why isn't there reasonable suspicion of negligent operation here?
Mark Lane is a traffic violation. It doesn't rise to the endangering the lives and safety.
No, you're weaving out of the lane. You're inferably smoking marijuana while you're driving on a highway. The cloud of smoke is so thick you can't even see into the car. So why isn't that enough for reasonable suspicion of negligent operation?
So now that hasn't been briefed at all, but now we're trying to make up another reason that might justify her removal. Even so, that suspicion would have to be justified. It would have to be confirmed or dispelled. And all the things that the trooper saw that showed she was not impaired would also dispel any suspicion that she was operating negligently. I see my time has expired.
Let me just check. Any further questions from the panel?
No.
Excellent. Thank you, Attorney Linson. We will now hear from Attorney McLaughlin.
Morning, Your Honors. May it please the court, Assistant District Attorney Laura McLaughlin for the Norfolk District Attorney's Office. At the time the trooper issued the exit order, he had reasonable suspicion that the defendant was operating under the influence of marijuana as well as unlicensed operation. At the time the trooper made the exit order, he had previously observed the defendant make a number of marked lane violations and drift in and out of the breakdown lane. When he approached the vehicle, he observed a cloud of smoke come billowing out. He testified that it took approximately 30 seconds for the smoke to clear for him to be able to actually see in the vehicle. When he approached the vehicle and was standing at the side, he could not see into the vehicle. He could not see the operator or any passengers until that immense amount of smoke dissipated. At the time the smoke dissipated and he was able to observe into the vehicle, he saw one occupant, the defendant, operating the motor vehicle. It's reasonable at that time for the trooper to believe that the defendant was actively smoking marijuana at the time of her stop or in close proximity to the stop, given the sheer volume of the smoke. In combination with the marked lanes violations and his observed operation, he was within his permissible bounds to order the defendant out of the vehicle to confirm or dispel his suspicions. In addition to his investigation of whether the defendant's operation to safely operate a vehicle was diminished due to a consumption of marijuana, the reasonable suspicion factors would also support the identifications that the defendant produced.
Let me stop you right there. Assume that there was no marijuana smoke or odor in this particular case, and the officer stopped just for a marked lanes violation, and she produced a Dominican application with which the trooper was not, or officer was not familiar. Is that in and of itself sufficient to justify an exit order? Just the lack of familiarity with an out-of-state or out-of-country license?
Your Honor, in that hypothetical, supported by the facts of this case, yes. Here, what the defendant produced is a Dominican, what the trooper referred to as both an identification and a license. He did not have any understanding about the validity of that identification. Further, there's no evidence in the record that, one, the defendant possessed a Dominican driver's license in the Dominican Republic, that there was any valid license in that country. Further, what she produced was in fact a Dominican driver's license. What the trooper was presented with was
so go back to my question, which is a little bit more of a hypothetical, which is, are you saying that if a law enforcement officer is not familiar with the identification that someone shows him or shows her upon a motor vehicle stop, then that in and of itself is a legal basis for an exit order?
If the other facts suggest that he has reasonable reasonable suspicion that a crime is occurring. So if he is unable to confirm with dispatch whether it's a valid license, or if supported by other factors in his reasonable suspicion analysis, such
Did
as
he make the call to dispatch here prior to the exit order?
I believe so. I would have to check with the record, but what happened here is that the license that was, or identification, whatever was produced, was inconsistent with her US issued passport. So what the—
But the trooper testified on cross-examination that he made no efforts to verify whether the Dominican identification was valid or not.
Mhm.
So
Well, I think
given that admission, is it reasonable then to order someone out of the car?
Well, the Commonwealth never conceded that there was no reasonable suspicion for the exit order. What they argued in the motion to suppress and the interlocutory appeal is that the trooper did not have probable cause to arrest.
No, I'm asking, following up on Justice Nyman's question, is, if someone hands over a document, out of country document, that and the officer isn't familiar with it and makes no efforts to verify whether it is in fact a valid license, is there then reasonable suspicion of operating without a license? Is that
on those factors alone, perhaps, but as your honors know, the reasonable suspicion is very fact specific, and each fact alone might not support reasonable suspicion, but in combination of all the factors presented would give rise to reasonable suspicion.
Just what are the other factors here besides the ID he was unfamiliar with?
Here you would have the identification, the fact that there's no record evidence in the record whether she did possess a license. Under the statute, unlicensed operators with an out-of-state country or out-of-state license are able to operate in Massachusetts for a specific number of days. There was no evidence of how long she had been in the Commonwealth for. Here, the fact that the passport and the identification had different spellings of her name are one factor that the trooper had in his reasonable suspicion analysis, given the fact that inconsistent identifications would support a heightened awareness.
The absence of the information, the factors that you were speaking of was an absence of information. How does that cut? In favor of the prosecution or against the fact that we don't know how long this person has been residing, or if that person has been residing in the Commonwealth? Is that something that was incumbent on the officer to determine?
Perhaps if that was his only basis for issuing the exit order. The unlicensed operation, or his belief of an unlicensed operation, which, excuse me, let me correct that. There's nothing on the record of the trooper's subjective state of mind at the time he issued the exit order. So we cannot speculate whether he made the exit order solely for his belief of unlicensed operation, or if he made the exit order because of his reasonable suspicion, given the combination of factors of the observed operation and the smoke of marijuana. We cannot speculate of what his mind was. What this court would look at is the number of factors and whether at the time he made the exit order, there was reasonable suspicion that a crime was occurring. The Commonwealth's position is that he did have substantial reasonable suspicion that at the time of the exit order, that the defendant was operating under the influence of marijuana, as well as what could be considered and further needing to further investigate an unlicensed operation. An exit order is an intrusion, however, it's a limited intrusion to allow the trooper to further confirm or dispel whether a crime is occurring.
There's no reason to have somebody exit a motor vehicle to investigate the validity of a license, correct?
If those were the only factors alone, perhaps. However, if the facts presented otherwise, that alone could be sufficient if, especially where here there are inconsistent identifications. If the trooper needed to confirm the identity of an operator of a motor vehicle, that is a safety concern. That is permissible for a trooper to have someone limitedly step out of the motor vehicle to confirm whether they were in fact operating. But the facts here would produce a number of combinations of facts and observations by the trooper that would support the reasonable suspicion for that exit order. And at the time of the exit order, the defendant was immediately given her Miranda warnings as found by the motion judge. She understood those rights. And when the trooper asked if there's anything he should be aware of, she immediately offered, "Not that I know, you can search." That expanded the scope of the stop and was appropriate given the consent to the search that she knowing and voluntarily waived her Miranda rights to give to the trooper. For all those reasons, and the Commonwealth would rest on its brief unless your honors have any additional questions.
Seeing none, we thank you both for your arguments and your very helpful briefing, and the case is
And we are back live and on the record.
Good morning. Calling the second case on our list today, Commonwealth versus Jones, matter 2019 P 1622. We will hear first from counsel for the appellant, Attorney Benyon.
Thank you to the presiding justice, and may it please the court. I represent Mr. Jones, and I want to start with the first argument that's in the brief. And this is one where I'm sure you're going to take careful note of the transcript, and I think I'll go through it. But what the argument is essentially is that the government never proved beyond a reasonable doubt anal rape. So if you have your transcripts up, I'm going to mainly be going through transcript volume 3.
9798, right?
So basically, if you follow the testimony of the events, it doesn't show that anal rape was committed by Mr. Jones. So for example, if you look at page 96, Mr. Jones told Mr. Herbert that he should, quote, put it in her butt. This caused the victim to reel back and said no. Mr. Herbert then kind of laughed, and she testified that, she testified that he did it anyway. So from the context of that, you can understand that Mr. Herbert, there likely is evidence to show that Mr. Herbert committed anal rape, even though she didn't say it. And while the government in its brief says that that similar context can be applied with respect to Mr. Jones, it can't. And let me walk you through why it can't. Because what we're talking about here is on page 96 and 97, Ms. Doe says or testified that they switched, meaning Mr. Jones was behind her and Mr. Herbert was in front of her. This seems to be the event that caused the indictment for anal rape, but she doesn't say, or she doesn't give a testimony that would have allowed that to be proven beyond a reasonable doubt. In other words, the testimony has to be shown to meet the elements of the crime. And in this case, it's likely because this is sensitive testimony. It's always difficult to put a victim of sexual assault on the stand. But viewing this from Mr. Jones' point of view, while we're not contesting vaginal rape, we strongly contest anal rape because all that the government was able to show was that they switched, meaning that Mr. Jones was behind her. And
well, isn't there more than that? You have me at pages 96 and 97, and I hate to get into this level of detail, but starting at the bottom of page 97, John laid on the ground so I would be on top of him, and Jake was behind me so that John could be in me vaginally and Jake was in me anally. Did you say yes to this? Answer, no. I asked them to stop. Question, did they accomplish that? Answer, yes. Would you say they were holding your shoulders? Could you describe the kind of the grip? It wasn't very hard, just enough so that I couldn't move, I couldn't get up. What happened after that? Answer, they took turns. So then Jake would be under me and John would be behind me. Question, in the same way you just described? Answer, yes. Question, and did they accomplish that? Same question they asked before. Answer, yes. I'm having great difficulty under the Lattimore standard understanding why that does not satisfy proof of anal rape.
Because as he's behind her, and as you go throughout the testimony, at no time, except for with respect to Mr. Herbert, does she talk about anal penetration. And even in that portion that you just read, proof beyond a reasonable doubt has to be more than just this idea that that it can be a kind of an amorphous testimony that kind of allows the government to seek this kind of a penalty. I mean, understand.
Counsel,
Yes.
amorphous testimony, the testimony seemed to indicate that they were both penetrating her at the same time, vaginally and anally, at the same time. That hardly seems amorphous.
Oh, again, I'm only talking about with respect to Mr. Jones and the anal rape. I'm not talking about the vaginal rape. So yeah, my client feels that this testimony does not allow the government to meet its burden. The difficulty here is you have such charged testimony that oftentimes jurors will just kind of gloss over this kind of detail in the testimony. And that's what your job is to go over that testimony and make sure that the evidence meets that proper standard of beyond a reasonable doubt.
Would you agree that if they had just said they took turns without more, that's a different case than they took turns in the same way you just described and they accomplished that?
Yes, but you don't know, again.
In the same way you just described.
Again, that is not accurate with respect to whether the person behind could penetrate anally or vaginally. A follow-up question would have had to have been asked. In this case, it's possible, and I'd like you to consider that maybe the government knew that she was waffling with respect to Mr. Jones and her and the anal rape count. In that case, this kind of testimony allows the government to seek a prosecution, to get a prosecution without getting that detail of beyond a reasonable doubt. Again, you know what beyond a reasonable doubt is. I'm aware of what Lattimore says, but in the end, the government has to prove its case. And in this instance, all they had to do was a simple follow-up question. And because they didn't, that raises serious questions, because I say amorphous, and I think I'm right, because from behind, there are two options for Mr. Jones. And in the same way, while it allows you to get there, it points in a direction, it doesn't get you beyond a reasonable doubt. It might be by a preponderance, you could use that language, but beyond a reasonable, it has to mean more for this kind of a charge. It can't be this type of I'm not sure what the word I'm looking for is, but it can't be this type of trying to avoid the word amorphous, but it's got to be more. I mean,
well, I think you're saying there's an ambiguity, but again, after describing the simultaneous rape, the victim states they took turns. So then Jake would be under me and John would be behind me. And again, in the same way you just described, yes, in the same way you just described was in reference to the simultaneous penetration. And the follow-up question, and did they accomplish that? Answer, yes. So I'm having difficulty thinking what else that could mean.
Well, again, from behind, there is the possibility of either anal rape or vaginal rape. And in every other instance, Mr. Jones is shown to be accomplishing the attack through or vaginally. If you look at it as a whole, if you look at this testimony, we just don't feel that proof beyond a reasonable doubt is met here, just because, again, a simple question, did he penetrate you anally, is left unanswered.
Can I ask another question, and this will segue into the joint venture issue? I know that the joint venture instruction was given on the issue of aggravated rape. I guess my question is, was this case tried, though, as in any way, as a joint venture case overall? Is the answer to that yes or no?
I think that the answer is yes, if you look at the way the government tried the case and if you look at the instruction.
So if one person is raping the victim anally and the other is raping her vaginally and they're both holding her down, why could that not support a conviction under a theory of joint venture? In other words, why wouldn't each be responsible for the other's action?
So if you look at, so first of all, trial counsel objected, both trial counsel objected to this instruction. It was given multiple times. My client feels that he wasn't, or that the mens rea element wasn't met. He feels that if you look at the instruction, aiding and abetting without the mens rea, he feels was improper.
Pardon me, counsel, where is an instruction on joint venture as opposed to joint venture being the aggravating element? There wasn't a general joint venture instruction given, right? That to me was the import of the jury's question, which is that elements 1 and 2, I think a jury would interpret that to mean that the defendant had to personally commit the act of penetration. And then element 3 was the joint venture, the aggravating element. But I didn't see a general joint venture instruction.
No, I think you're right. But it's the way that the case was presented and then the instructions given that I think allows my client, or gives my client pause. You can read the instructions that were given, but my client feels that without the mens rea, that the jury was allowed to convict him just as an aider and abetter, I think is his point. So just go to the, and you're right, the jury did come back with a question, if I can find it.
This was the question regarding the oral rape.
Yeah, I think it's at volume 7, page 12.
Thank you, Judge Nyman. So my client wants, or is putting forward the position that the jury should have been instructed that a defendant is guilty of joint venture crime if he knowingly participates in the commission of the crime charged with the intent required. He feels that, again, that wasn't met. But
the instruction that was given, both the written instruction and I'll call it the second instruction, the replacement instruction, The judge specifically said whether the defendant personally committed the crime or aided and abetted or assisted others in doing so, the Commonwealth must prove that he had or shared the intent required for that crime. So why is that not sufficient?
Again, trial counsel objected to this. It was discussed back and forth among the parties. It's an issue that my client wants to raise. And again,
trial counsel didn't object to the instruction. Right. I mean, there's no, once the judge decided on this language, I didn't see any objection.
Oh, that's true. The okay. Final one. And there was some back and forth with respect to this. But yeah, so again, I think that one of my client's other points is that he wants to put forward is that because the instruction changed, there is a chance that the jury might have been confused, and because of the charged nature of the testimony, the jury may have wanted to convict just out of an overabundance of caution. But again, he feels that he did not, or the government did not prove that he had the same mental state as.
But what is the mental state that would be required?
Well, I think it would be the mental state of the person accomplishing the crime.
But what mental state was required for this?
Well, I would guess it's a state to, again, accomplish the specific crime. And when I say specific crime, I think it boils down to whether you want to, or whether there was an intent to commit a specific act, either vaginal or anal.
Okay, your time has expired. Any further questions from the panel? Thank you very much, Attorney Benyon. We'll hear from Attorney Greenbaum. You're on mute, sir.
How about now?
Terrific.
Okay.
Could you actually start by clarifying, was this case tried alternatively on theories of individual responsibility and joint venture, or just the former?
Or just the former. Well, what was odd, and I can't give you a direct answer. The way they were instructed, they weren't instructed about any lesser includeds, and I think of simple rape, so that they were given the first two elements of simple rape of penetration and against will, and then the third element was participating in a joint venture. And if you found a joint venture, you could find aggravated rape. They weren't instructed that you could find someone guilty of rape if they engaged in a joint venture but hadn't done penetration. They weren't told that specifically.
Right.
So,
and they also weren't instructed specifically that if you find that person A was committed vaginal rape, did not personally commit anal rape, but assisted, aided, all the elements of joint venture,
right,
that he could still be found guilty under a theory of joint venture.
That's right. Yes, I think they were instructed that a joint venturer who did not commit the specific act of penetration but aided and abetted could be convicted of that act of penetration as aggravated rape. Yes.
So in other words, the joint venture instruction in this case went solely to the issue of aggravation, not to a separate theory
of liability,
of criminal liability. Yes. You would think there would need to be a separate instruction to that effect, apart from just the aggravation aspect.
I would have thought so too, but where it's listed as I don't think it's so clear that the instruction didn't indicate if they found the person guilty found there was a joint venture and therefore found that an individual who hadn't engaged in the forceful penetration was guilty of aggravated rape, then by necessity they have sort of found that the person is liable for the rape anyway. Even though
the question doesn't make sense at all unless the jury is interpreting the instruction to require personal individual liability on elements 1 and 2. Otherwise,
That-
it just doesn't make sense, because the premise of the question is, if we find the defendant be guilty of element 3, but not guilty of elements 1 and 2, how could that possibly ever be?
No, I agree with Your Honor, with your interpretation of what the jury's question meant and their understanding of the instructions. I'm not sure that that's their understanding of the instruction was correct or the instruction was clear enough. That's what I'm saying. Yes, they believe that in order, or, and I think I even have it in a footnote somewhere, it's possible they were not totally convinced that the oral intercourse was non-consensual. But that's another.
As to the co-defendant.
Either one, yeah. Well, I don't think there was any specific testimony that, going back to the defendant's position, there's no specific testimony or even inferences that as to the defendant Jones, there was oral intercourse. That part of the testimony, if you look at it, the first part talks about, here we go into the details, that Mr. Hebert, they switched positions. Mr. Hebert, the defendant is behind her having vaginal intercourse. Hebert gets in front of her, the co-defendant, and either forces her to, she says, he holds my head until I gave him oral intercourse. Now, whether that's forceful or not, I don't know. And then they say they switch positions, and the defendant, Mr. Jones, is in front of her by her head, and she just keeps her head down. She never specifically says that Mr. Jones, Jones forced that she had oral intercourse with the defendant. So that was that state of that evidence. And I believe they interpreted where you're understanding it, Judge Shin, that well, we can't find him guilty of aggravated rape unless he penetrated as well. I don't necessarily believe that that's what the instructions intended for them. That's how they interpreted them. It's a very, having done in trial aggravated rape cases, the instructions can get very complicated. And it's hard to convey the difference between joint venture liability and the aggravator of joint enterprise.
Well, in your experience, I don't want to go too far afield, but in your experience, when a case is tried on a theory of aggravated rape, on a theory of joint venture, and the Commonwealth is pursuing a separate theory of liability under joint venture, isn't it the norm that the judge would give an additional joint venture instruction?
Yes, the judge, certainly would have been my preference in this case if the judge had instructed on joint venture liability for rape itself.
So that begs the question then, which is, assuming this was not tried as a joint venture case in terms of theory of liability, it was just tried as a joint venture in terms of the aggravating circumstances. Does it make a difference under these facts?
Let
me ask you this way.
What does what make a difference? I suppose that's how
complicated. Fully for his question. So my question is the evidence sufficient here? Was the evidence sufficient for the Commonwealth to prove that each defendant acted individually as to the convictions for
anal rape
and anal rape?
Yes, precisely on the basis of what Your Honor has already gone over in the transcript. I don't think there's any ambiguity there. I think I just feel like the defendant is attempting to conflate the earlier testimony about when they're in positions doing oral, and then when they decide we want to penetrate both orifices, and they engage in that activity. And she's very clear about one did one did the other, and they did the same thing and switched positions. And the same thing was one anal, one vaginal. And I'm not going to go into detail on my footnote, but there's an anatomical issue here too that I think comes into play as well.
So the judge's response to the question, whatever happens on any other indictment should not and does not affect or control you with respect to another indictment. That's not technically accurate. Would you agree with that?
I'm not sure I agree. Can we go over that question again? Because it's in terms of what he's instructing them. Go ahead. I'm sorry.
So the judge says whatever happens on any one indictment should not affect what happens on another indictment. And that's not accurate, right? Because had the jury convicted one defendant, and this is obviously hypothetical, that's not what happened, but had the jury convicted one defendant of aggravated rape based on, let's say, oral penetration, but not the other, that would be inconsistent.
I agree. What the judge said was not accurate when he told them it won't affect what happens. But what I would suggest is the judge at this point is instructing the jurors on how to go about their deliberations. And what he's trying to get across is don't be thinking about when you're deliberating about one count, how it might affect another count. Think of them each separately. So I think that was the intent of the judge, not to tell them about the legal possibilities of an inconsistent.
Because he didn't want to convey to them that it's an all or nothing, and that
that's right. I don't think he wanted, because if he had given the requested instruction and there were these convictions, I can see either defendant coming back and say, hey, wait a minute, the judge said consider it all together, and they didn't like the co-defendant, and therefore they convicted my guy too. So I think the judge's decision not to give that requested instruction was a wise one, as I've said in the brief.
Okay.
I've got nothing else to add unless there, well, as the court well knows, in terms of the claims about the instruction being confusing and whatever, the jury had a written copy of the final instructions with them, and presumably that would have made things clear. And I stand by my argument about that they couldn't have been confused about the shared intent element. And if there are no other questions, I'm resting.
Seeing none, we thank you. Thank you both actually for your full arguments and your very thoughtful briefing.
You're welcome.
Should I begin, Your Honor?
Not yet.
Okay.
And we are back live and on the record.
Excellent. Calling our third case today, case number 2019 P0989, Abdullah versus Commonwealth, and we will hear first from counsel for the appellant, Attorney Keneally.
Thank you, Your Honor. May it please the court, Your Honors, my name is Joseph Keneally and I represent Mr. Abdullah, formerly known as Ronald Flynn. For purpose of his appeal, Mr. Abdullah is appealing a trial court judgment designating him as a sexually dangerous person pursuant to Section 9 of Chapter 123A. The appeal involves several rulings by the trial court and a host of evidentiary issues that the petitioner submits represented abuses of discretion on the part of the trial judge. And viewing them as a whole prevented him from presenting a fair presentation of his case and violating his right to a fair trial. Now, the first issue I want to raise involves the testimony of one of the expert witnesses, the qualified examiner, that she designated Mr. Abdul to be a high-risk offender. Now, as the court knows in Commonwealth versus George, the SJC ruled that static 99 risk category labels, the labels that designate individuals as low or moderate or high risk to reoffend, that were attached to the static 99 scores were inadmissible at trial. The court said that the numbers, the scores themselves, 1 through 6 or 1 through 12, were admissible, as were the percentages that were attached to those scores. But the labels themselves, the risk category labels, were not admissible. And the court said the reason for that was because there's really only a loose association between the natural language and the verbal labels for purposes of likelihood. The numeric probabilities are not really communicated through these labels. And the court said they were not.
I'm sorry to interrupt, but background question. Initially, there was a motion in limine, and the judge said, my understanding anyway, is that the judge said, yes, we won't get into the category labels.
Yes.
Subsequently, there was some testimony, and the judge revisited this, and the judge actually took a look at I think it's called the evaluator's workbook, and she specified certain pages that she was looking at. I didn't see the evaluator's workbook in the record appendix or anywhere in the record in front of us. So it begs two questions. One, am I mistaken? And two, was it ever admitted as an exhibit at trial?
No, Your Honor. It was not admitted as an exhibit at trial, and nor was it marked for the record. And it was not included in the appendix. If it was an error to not include that error is mine, and I apologize for that. But
well, if it's an error, but it's just, it is what it is. And so for me anyway, that brings to mind two questions. One, I'm having a little difficulty understanding exactly what the judge looked at, because this seems to be a little bit different than the George case. And I would also note that at least at trial, counsel didn't referenced the George case, didn't make an objection under George. So I guess that begs this question. What is the standard of review here? Is this a really substantial risk?
I don't believe it is, Your Honor. I believe that the error was preserved because the reason why it was being objected to was that these risk reference categories that we're talking about here are different than the risk labels that were found to be inadmissible under George. These are two different things. The risk category labels is when you do a static 99 assessment, it's 1 through 6, and each one has like low risk to reoffend, moderate risk to reoffend. This is a different thing. This is called a risk reference sample.
Right. So unlike George, the witness didn't say here, I find him to be high risk. This is a little bit different, right?
Well, I mean, what happens is in these circumstances is an evaluator will do the static 99 evaluation. They'll come up with a score, and then they'll decide which of the two pools of reference samples the subject should be in, whether they should be in what's called a routine sample or whether they should be in a high risk, high need sample. Okay. And the petitioner's not appealing the qualified examiner's decision to place him in the high risk sample, nor is he appealing the qualified examiner's the attachment of the percentage that went to that sample. What he's appealing is the reference to the defendant as being in a high risk group. Okay, and I think that's where George comes in. Because
was that elicited? I'm sorry to interrupt. Was that elicited on cross-examination or direct examination?
Well, it was originally brought in during direct examination to the extent that counsel for the Commonwealth asked the expert whether or not what talked about the high risk group as well as the routine group, brought it in. It wasn't until voir dire and later that she actually said, I apply this man to the high risk group. But the issue is, if in fact he didn't apply to this group, if she wasn't intending for him to apply to this group, then the evidence would have been irrelevant. There'd be no reason to introduce.
I understand that, but it seems to me that the testimony that is being objected to on appeal or is being challenged on appeal was actually elicited during the voir dire and then actually raised on cross-examination. I mean, the meat of the issue, that's what you're providing earlier context as to how it came up, but that's not where the objection was.
Well, I mean, the fact is that this high risk element came in during direct examination because they brought up the issue that the category exists and that she was contemplating that. Now, if she had said—
I thought you just said that you are not challenging that testimony, that it was proper for the expert to say the group recidivism rate for the high risk group is whatever it was.
No,
are you challenging that?
I'm not challenging the expert's decision to place him in that category. What I'm challenging is the use of the term high risk, the use of the label high risk, because according to the static 99 score that he got, if you had applied these risk category labels that were found to be inadmissible in Commonwealth versus George, then he would have been listed as a moderate to high risk to offend. In this case, we had reference to him being a high risk. She basically introduced this whole notion that he was in the high risk pool. Okay.
Where is the relevant objection in the record? What page of the record appendix?
I don't have that right before me, Your Honor. I would have to pull out my.
Because the only objection I see is at record appendix page 376, but their trial counsel objected to a lack of foundation. It had nothing to do with a George type of challenge.
Well, he did, and he didn't reference George. I mean, because this is not strictly a George situation, because we're not talking about them looking and saying he's a 5, so he's a moderate to high risk to reoffend. This is the argument here is that just the use of the term high risk is a problem. Because
are you saying that since this was elicited on cross-examination, are you saying that you could not have done a proper cross-examination without having elicited it?
Well, I mean, I think that the jury would be left to wonder exactly why it is that they're talking on direct examination. about him being in the high risk category. The high risk category actually even existing for purposes of its application to the petitioner. In these circumstances, if there was no application to the petitioner, the evidence would be irrelevant. If the petitioner tried to introduce into evidence the percentage associated with someone, say, who scored a 2 on the static 99, that would not be admitted because it's not relevant, because it doesn't attach to the petitioner's case. The very fact that they brought this up, that this was introduced during the trial as part of her evaluation, meant it had to attach to the petitioner's case. It had to have something.
If there's adequate foundation, as the judge determines, what is the error?
Well, the error is not that she put him in this category. The error is not that she was that this percentage in the high risk category applied to him. The error was the reference to the language high risk. The same way the error in George is the reference to calling some high risk. If you're going to score a 6 on the static 99, pursuant to George, the risk category label says you're a high risk to reoffend. The SJC and George said, you can say
what should the expert, how should the expert have phrased it then?
The expert should have done just what they're suggesting in George, Your Honor. They should have just given the score, the 5, and given the percentage that applied to the 5, even if it was in the high risk pool, but not use the language high risk to reoffend. Because for the reasons stated in George, it isn't helpful.
But you can't just give the score and the percent. I mean, it depends on which sample you're in, right? I mean, so the expert first said, here's the group recidivism rate that applies to the routine sample. And then here's the rate that applies to the high risk sample. I don't know how you can get that testimony out without applying the labels to each sample. And it's still up to the jury to determine which sample the petitioner falls within, right?
Well, George said that the labels shouldn't come in, and Your Honor, it's fairly easy to do. You could say, I conducted the static 99 evaluation. I gave the petitioner a score of 5, and in this, based on his score of 5, people in that pool are 22 or 15% chance to reoffend. It's as simple as that. The whole notion that he's called a high risk to reoffend is absolutely unnecessary to this examination. And the court in George said that language like this is unhelpful to the jury because it confuses them and it sort of usurps the jury's role in determining likelihood of reoffense.
Well, an expert is still entitled to opine as to whether an offender is high risk, right? I mean, George was addressing something very specific.
Yeah, George was saying, don't take labels like high risk and introduce those into evidence.
Well, it says don't use them if they are, I forget the exact phrase, I'm trying to look for it, but if it's unconnected to specific meanings, such as recidivism rates, psychological features, expected treatment needs, etc. Here, at least I believe Attorney Mansfield is arguing that it was connected because during voir dire, for example, Dr. Vasher, if I'm pronouncing that correctly, explained that the high risk or high needs group includes people with higher treatment needs, a certain history, responsiveness to treatments, and the sex offender's behaviors. So there was context to the reference to the high risk, high needs group. It wasn't just a standalone label.
Well, I mean, ultimately the judge says that based on her review, she could not determine whether or not he would fall into the routine sample, or whether or not he would fall into the high risk sample, and said that since he qualified for possibly both of them, she was just going to let her have it and have that be admitted. Now, all that evidence that you raised, Justice Neiman, is certainly something that she could discuss, and she did discuss, and there's no objection to it. But she didn't need to inject the high risk in here, because that's what the jury's supposed to determine, whether someone's high risk. And when you have a situation where you have an expert saying
the question here, the question was still given to the jury. I mean, what George prohibits is an expert coming in and saying, because the offender has this static 99R score, that means he is at a high risk to reoffend or moderate risk. That is what George prohibits. Here, all the expert said was, here are the group recidivism rates that correspond to each sample, but it's still up to the jury to determine which sample he falls within, right? I mean, I'm having a very hard time seeing what exactly is the error here.
Well, she testified that he scored a 5,
Right.
and she testified to the percentage risk of reoffense for people who are in that pool. All that's admissible. She testified as to why he would fall into that group. The only thing where she crossed the line, the same way in George, is when she starts attaching terms like high risk. When she starts attaching language like that, which George said, you don't need it in a static 99 evaluation. You don't need to take someone with a 6.
I read when she says on cross-examination, I find he's at a high risk. I read that to be her opinion based on her assessment of all of the circumstances of the case, not that she's saying because he scored as a 5 on the static 99R that he's a high risk. And that's proper, right? It's proper for her to opine on that.
She said both. She said, I felt like he was a high risk to reoffend, but she also said that she placed him in the high risk reference sample group. And the judge asked her to explain exactly why that was the case, that she was put in that reference sample group. And I would submit she was entirely unable to articulate a response to the extent that the judge herself had to refer to the evaluator's manual to come up with some sort of understanding as to why he would belong in that group. And ultimately she decided that she couldn't tell. He seemed to apply to both groups. And given that was the case, she was going to let the witness have the high risk designation. The only thing I'm suggesting here is that the language that's being used, the label attached, high risk rather than routine sample, is something that's unnecessary to be admitted. And that the analogy drawn is to the labels that were referred to in Commonwealth versus George. If someone's a 6, you don't say they're high risk, you just give the percentage. If someone's a 5 and they're in the high risk needs group, you don't say high risk needs group, you just give the percentage. That was the basis of the defendant's, of the petitioner's claim here. And that's the source of the error that he's talking about. Now, I understand I have 9 seconds left here.
We can give you, we've asked a lot of questions. So if you would like to address any of your other evidentiary issues, we can give you another couple minutes.
Yeah, I'll briefly, Your Honor. I would want to bring up, for example, the notion that the defendant was not allowed to introduce evidence that drugs were available at the treatment center for purposes of making his case. All the Commonwealth's experts in this case testified that the defendant was likely to reoffend if released because he was a substance abuser and he was unable to control his antisocial impulses, even in a restricted environment such as the treatment center. And they give a long list of things that he had done during the course of the treatment center. In order to dispel that notion, the petitioner was pointing out the fact that in all of these years, he was never found in a situation where he, in fact, was caught possessing drugs or being under the influence of drugs. And he sought to introduce the fact that this was not something that's just because of a restricted environment. A jury might have said, well, of course he wasn't found with drugs because he was in a prison, but he was intending to introduce evidence that, in fact, drugs and alcohol were readily available in the treatment center, and he was prohibited from doing that. That's an important thing because the Commonwealth's one of the major portions of the Commonwealth's case is based on the fact that this man cannot control himself, and the evidence is even in the facility he cannot control himself. He needed to show that he could control himself, that one of his biggest problems he was overcoming in the system, and that it wasn't by virtue of the circumstances of his imprisonment that was preventing him from doing it, but in fact, he intentionally abstained, and that would go, I would suggest, a great deal towards demonstrating that these allegations that he had impulse control problems to the extent that he couldn't even avoid problems in prison was in fact not true. And I think it would speak to the whole issue of the experts' assessment of him to this extent in general. So I think that something that should have been introduced. There are other instances too. I know I'm out of time, but involved the issue of him attempting to get stricter probationary terms and the inability of one of his witnesses to testify as to the full extent why he didn't diagnose the individual as sexual sadism.
You know, and those issues are very well spelled out in your brief. So.
They are, Your Honor. So I thank you for the extra time, and I appreciate your time.
Wonderful. Thank you for your argument.
Thank you.
Attorney Mansfield for the Commonwealth.
Good morning, Brian Mansfield for the Commonwealth. This court is 100% correct that when the high-risk sample group was used, that is a completely different thing than the labels that were discussed in George. The labels in George were not connected to a mathematical recidivism rate. In this case, Dr. Bashir simply said the routine sample for somebody who scores a 5 has a recidivism rate of 15.2%. The high-risk sample has a recidivism rate of 21.2%. She did not testify on direct, as the court pointed out, that she would place him in the high-risk sample, which is not what you do. You can say, I used the high-risk sample because he resembles that group, but she never said that she placed him in any particular group or said that she found him to be high risk until she was cross-examined on that.
Understanding that the label is high risk group, that's what it's called.
Right.
In light of the SJC's concerns in George, would there be another way to articulate this? I know you have the routine sample and then you have the high risk sample. I'm wondering how this could be avoided in the future.
I mean, you could give the range of, as counsel suggested, recidivism rates, but because I think it's important to distinguish why there is a range. There is the routine sample, which is most like the entire universe of sex offenders in custody. It's a broad range of offenders. They use the term high risk to differentiate from the routine group for people who have been pre-selected for treatment or selected for preventive detention, like a civil commitment. So it actually applies, it is pertinent for the jury to understand why there is two.
Right, so why couldn't, I mean, I suppose going forward, counsel for a petitioner could file a motion to eliminate and say, we don't want to use these labels. So for the routine group, instead of calling it the routine group, you could say, this is our analysis for people who fall into the overall sex offender population. And then for the high risk group, instead of calling it that, say, and this is the template, or these are the protocols or the measurements we use for people who've exhibited a history of X, Y, and Z, as opposed to using the labels. Why couldn't that be done going forward?
I mean, it could be done, but it was not done in this case. What was the motion in limine addressed the labels, which would strictly have been the testimony had that been admitted was Mr. Abdullah scored a 5, which places him in the moderate high risk group without any mathematical recidivism rate attached to it. And here it's, although the language is similar, it's a group of offenders who recidivate at a higher rate, and that's why that label was used. I mean, as this court recognized this summer in a case, a SOAB case, and they called SDPs a particularly menacing subset of sex offenders. So you can see why it's relevant, because SDPs aren't like the routine sample in a lot of ways, because they are that menacing subgroup of sex offenders.
With regard to the challenged testimony, the testimony that is now challenged on appeal, am I correct that it was elicited actually on cross-examination by petitioner counsel, or was any of it elicited on direct examination?
None of it was elicited on direct examination before the jury. There was some discussion during the voir dire, but there was she was not asked either of those questions. Which group would you put him in, and do you find him as a high risk offender? So on cross-examination, she was asked the question, you testified that you would place him in the high risk group. That testimony had not occurred in front of the jury. So it was entirely brought out by Mr. Abdullah.
So you could avoid the use of the words routine and high risk if the expert just opines as to her opinion about which group recidivism rate applies, right? So if she had just gotten on the stand and said, here's his score is 5, and in my opinion, that correlates to a rate of 21.2%. Would that be proper?
Well, if she's cross-examined on why she uses, and that would be the case, that she's going to be, and she was subject to cross-examination on this, is why use the higher recidivism rate or the other sample.
Right. My question is, I'm just going back to Justice Nyman's initial question, which is, if the objection is to the use of these words, and is there an alternative way so that you don't use these words, would it be proper for an expert to testify as to the rate that he or she believes applies without saying, here's the rate that applies to the routine sample and here's the rate that applies to the high risk sample? Would that be proper?
It would be proper, but I think to fully put it in context, there would have to be some explanation of what the difference is between the two sample groups. And that second sample group, the high risk one, for people who have been determined to need sex offender treatment.
Right. So there have to be an adequate foundation, and the judge could determine that, and then the expert would be cross-examined on that. But I'm not seeing any reason why, once the foundation is laid, that the expert couldn't simply testify as to the rate that she believes is applicable.
But that was, in this case, that was not the subject of a motion in limine. And once, the proper foundation was laid, the attorney objected, but did not object any further than that. And as Judge Nyman mentioned, there's only 2 objections, one at page 338, where he says he objects as to a foundation, and then after the judge makes her determination on page 376, he just says, note my objection. But again, these are not, as the court noted, not the same thing. We're not talking about the same thing that the George court talked about. As far as the issue about excluding testimony that alcohol is present at the treatment center, the qualified examiners and the community access board representative all testified that Mr. Abdullah is unable to control his impulses at the treatment center, but gave concrete examples, including an assault he had committed on another resident just several months before the trial, specific physical acts, verbal aggressive acts. Those are the type of things that they solicited an abundance of evidence on. The mere fact that he had abstained from alcohol really wasn't going to offer much, given the weight of where his impulses were not under control. But there was testimony.
Shouldn't he have been entitled to put that forward? Why prevent him?
Well, there was evidence that he had never received an observation of behavior report because he had been in possession of alcohol or drugs. So that evidence was in. The evidence that there was alcohol or drugs available at the treatment center was a very limited offer of proof that it would have come from 2 former sex offenders who had spent some time at the treatment center, but both of them had been released from the treatment center and had been gone for some time. There was no offer of proof that they had personal knowledge of alcohol or drugs available, or personal knowledge that Mr. Abdullah himself could have had access to it. In fact, both of those witnesses, neither of them testified that they even knew Mr. Abdullah. They only testified about services that would be available in the community where he'd be released.
But in fairness, didn't the judge shut that down before they testified? I mean, I'm looking at record appendix page 551, and the judge said, you already elicited that information, and it actually hadn't been elicited. I think the judge first of all, I think the judge made a mistake there. And secondly, I think she foreclosed this line of questioning and even said, I'm not going to allow them to get into that. So I'm not sure that it's fair to say that the proffer was insufficient.
Well, if they were depending on those two witnesses to provide, who aren't even at the treatment center currently, and didn't even testify that they knew while they were there that they knew Mr. Abdullah.
But they would not need to know him. Their relevance was having been there and knowing the circumstances of what it's like to be there and what's available.
And
I was there, and alcohol and drugs were readily available. Anytime I wanted alcohol, I got it. There was a person who sold it. Maybe there was a person in the cell next to, I mean, again, had the judge not foreclosed this, I'm not exactly sure. And perhaps it was trial counsel's obligation to make a more particularized proffer.
And there is, I mean, the evidence or the actual fact is that alcohol and drugs are not readily available at the treatment center. And so, I mean, had the qualified examiner...
We can't take judicial notice of that. So.
Right, I'm just, so... But that, it still would have had marginal relevance, I'm sorry, on Mr. Abdullah's ability to control his impulses, where he had so much displayed antisocial behavior. So where he was assaultive and verbally aggressive, had been suspended from treatment because of his aggressiveness in his treatment primary group, the evidence that he was unable to control his impulses was strong. So this would have been just marginal relevance that he did not or was able to abstain from alcohol at the treatment center. But the evidence of what he was not able to, or how he was not able to control his impulses was strong. Another issue Attorney Keneally brought up was the issue about Dr. Brown fully explaining why he did not diagnose Mr. Abdullah with sexual sadism. And Dr. Brown did exactly that. He said he did not see evidence of sexual sadism in any of Mr. Abdullah's offenses. And that's why he said that his conduct did not fit the criteria. The question that was asked to him was, well, what about his partaking in bondage with a partner when he was in the community? Isn't that evidence? Well, he's already said he'd seen no evidence of sexual sadism. So again, that was going to be of limited relevance. But more importantly, Dr. Brown was the second witness for Mr. Abdullah, and Dr. Saleh had gone fully into, again, his reasons why he did not diagnose Mr. Abdullah with sexual sadism. And he was asked the identical question, what about Mr. Abdullah engaging in bondage with his partner in the community? And he explained to the jury why that was not sexual sadism. So Dr. Brown's testimony on the issue at best would have been cumulative. And Dr.
Well, it's cumulative unless, of course, the jury chose not to believe expert A, did choose to believe expert B.
And Abdullah was also able to cross-examine and did cross-examine Dr. Bashir extensively on that issue and point to what the criteria is. And importantly, all three witnesses, although Dr. Bashir was the only doctor to testify that Mr. Abdullah had sexual sadism, all three of the Commonwealth's witnesses testified that he had a statutory personality disorder, as did Dr. Saleh, who testified about antisocial personality disorder. So the necessary mental disorder that is required there was very solid and strong evidence of that in front of the jury. So sexual sadism was just, again, it was just a more of a corollary diagnosis by Dr. Bashir, but again, she was extensively cross-examined on it. And both Dr. Brown and Dr. Saleh testified that, in their opinion, he did not meet the criteria for that. And unless the court has questions on any of the other issues, I will the Commonwealth will rest on its papers.
And we are back live and on the record.
Calling our next case on the list, docket number 2020P0447, Brooks versus Massachusetts Department of Correction. And we will hear first from counsel for Mr. Brooks, and that is attorney Matthew Disler.
Good morning, and may it please the court. My name is Matthew Disler, appearing on behalf of appellant Richard Brooks. I'm 303 certified and supervised by Joel Thompson of the Harvard Law School Prison Legal Assistance Project. Prisoners may appeal the results of their prison disciplinary proceedings through a certiorari action. This court has never decided whether the statute of limitations for that action runs from the date that a superintendent issues notice of a decision or the date that she signs that administrative decision. The answer is clear, however, that the clock starts at the issuance of notice. Therefore, this court should hold that Mr. Brooks's complaint was timely filed and reverse the Superior Court's order of dismissal. And this is so for three reasons. First, it is the result of the clear meaning of the statute, chapter 249, section 4, read together with the regulation that governs prison disciplinary proceedings, which, as relevant here, is 103 CMR section 430.18. Second, it is consistent with this court's own decision in Lookner as well as in other cases. And finally, the reading is supported by compelling policy and prudential reasons, and the Department of Corrections' alternative interpretation simply does not make sense. And I'll touch on that last point first, because I think it puts the implications of this case into focus. So there are two potential accrual dates here, February 1st, 2019 and February 4th, 2019. February 1st is the date that appears next to the superintendent's signature, and the February 4th date is the date in which the department actually issued notice of the decision. Now,
it was also it was also the date of receipt. And I just want to clarify that that issue is not before us, correct? Whether the accrual date is the date of receipt of the decision. We don't have to decide that.
Correct, Your Honor. As you noted, it is the same date as the date of receipt here because the date of the service of process was essentially the same for receipt and for issuance. But for here, the crucial question is whether it is the issuance of notice or the date of the signature of the decision. And I'd like to just briefly explain the implications of the department's argument here. If the February 1st decision date starts the clock, in practice, an inmate like Mr. Brooks would have less than the statutory 60 days to appeal because he would not know of any decision to appeal from until notice of that decision had issued. And crucially, the department offers no limiting principle to their argument. It follows from their argument that the superintendent could sign the decision on one date and then wait 10 or 30 or even 61 days and then issue notice of the decision, meaning that any attempt to appeal afterwards would be less likely to be timely or even completely untimely. Now, removing that ability to appeal is hardly consistent with the purposes of a statute that this court and the SJC has characterized as a remedial statute meant to be interpreted generously. So given that, I'd like to turn to the text of the statute and the regulations here. Chapter 249, section 4 instructs that plaintiffs must bring certiorari actions, and I'm quoting here, within 60 days next after the proceeding complained of. Under this court's precedents, that statutory language has been interpreted to mean that the proceeding complained of refers to the last administrative action. But because that term proceeding complained of is ambiguous, particularly in cases like the one here, we look to the regulations governing the relevant administrative proceedings to determine when that last action occurs. And here, 103 CMR section 430.18, and just to read so I get it right, states in relevant part, the superintendent shall normally decide an appeal within 30 days of its receipt and notify the inmate in writing of the decision with supporting reasons.
So if the statute is clear, we don't necessarily get to the regulation, correct?
Well, I think that the statute, first of all, it is ambiguous here. And I think if it weren't, then we would get to a situation that maybe other courts have addressed in cases like Lookner, where they're looking at alternative dates of the statute.
Let's talk about Lookner, because I think this is your challenge here. And I'm not saying it's an insurmountable challenge, but here's your challenge. Lookner at page 836 addressed, if not the same issue, a very similar issue. And there the court said, quote, neither the word notice nor the word receipt, however, appears in General Law Chapter 249, Section 4. Had the legislature intended to begin the relevant period from the actual receipt of a decision, it could have easily said so, as it has done elsewhere. And then Lookner says at page 837, in reference again to the cert statute, the legislature did not require notice or receipt of anything, much less findings, to start the running of the cert period, but rather specified as the triggering mechanism for the action the operative conclusion of the proceedings claimed of. So arguably, in Lookner, we rejected the argument that you're making, specifically that notice triggers the running.
Well, with respect, Your Honor, if I could just read the next section of that Lookner decision, I think the court stated there that the critical event occurred either on the date that the hearing officer issued the final decision or at the latest when Lookner received notice. So
your brother argues, sorry to interrupt, but your brother argues that dicta, in light of the language I just read, which seems pretty clear, it seems that the court was then saying, look, even if we accepted the argument here, you still lose under this set of facts. And I don't know that that's necessarily an unfair reading of that language of Lookner, but please address that.
Well, appellant's interpretation of Lookner is that it simply stated that notice and receipt are not clear in the statute itself. So what the court did there was it referred to the regulatory language at issue there, which in that case was the Committee on Public Counsel Services Attorney's Manual, which was binding on attorneys who participated with it. Now, in that case, the relevant language was that the executive committee officers or executive committee hearing officer's final decision marked the last administrative action, and the court seemed to have treated that itself as ambiguous. But I would note that this court last year in Rise versus Commissioner of Correction adopted appellant's reading of Lookner case, namely that either the date of the issuance of the decision or the date of receipt of notice was available still under Lookner.
Has that ever been a holding in a published case by this court?
No, Your Honor, but not to our knowledge. But the fact that Rise versus Commissioner of Correction addressed a very similar issue, we think is persuasive here.
As I read Lookner, and you can agree or disagree, the critical distinction is that the issue presented there was had nothing to do with receipt or notice of the decision, but the plaintiff was arguing that not until the full decision with all the findings supporting the decision were issued and I received notice of that, not until then did the statute of limitations start running. So that's my interpretation of Lookner. Would you agree with that, or do you disagree?
Yes, Your Honor. And in fact, this precise question of the date of issuance of notice versus the date of the signature of the decision has never seemed to appear before this court. So in cases like Lookner or in Malone versus Civil Service Commission or other cases, there have been questions of timeliness that have not directly addressed the issue of whether there's issuance of notice or the date of the signature.
I didn't see anywhere in Lookner when the original decision was mailed. I mean, because it wasn't presented to the court. The question was whether the statute of limitations is told until the issuance of detailed written findings. Mm-hmm. Right.
Correct.
Okay.
However, the question of issuance of notice does not necessarily require the issuance of the detailed findings here. For instance, if the result of the appeal had just been given in a sort of cursory fashion to Mr. Brooks, then Mr. Brooks would have been issued notice as to the results of his appeal.
So you're not arguing, let's say the superintendent issues an appeal form saying I deny the appeal and it's served. And then, 30 days later issues written findings. You're not arguing that you have 60 days from the issuance of written findings, are you?
Correct.
Okay. Thanks.
And I would just note that appellant's argument about the issuance of notice marking the relevant date for the statute of limitations has been picked up in other cases. So in Cruz versus Superintendent, this court observed, although finding that in that case the appeal was not timely, that the superintendent will normally decide an appeal within 30 days and then notify the inmate. The District of Massachusetts has also adopted similar language. So appellant's argument here is far from a novel interpretation of the statute or the regulations here. And importantly, in other contexts, other regulatory contexts, courts have also looked to the proceedings at issue to determine when notice was relevant and found that issuance of notice was relevant. So for example, in Wayland, which was an appeal from a district court license revocation proceeding, the court counted from the filing of the notice or filing of the decision in the record rather than the date of the judge's signature in the record. And that was the Superior Court. And in Columbia Enterprises, which was a zoning decision in the land court, the zoning appeal was marked, or with the accrual date of the zoning appeal was from the filing of the zoning court's decision, which was under the town bylaw, rather than when the decision was actually signed. So in other words, despite all the confusions of the individual regulatory situations, it's fairly clear here that there is a clear practice across regulatory contexts of counting from that issuance of notice. And I would like to touch on a couple of additional policy and prudential reasons that are relevant here.
Before you get there, I'm sorry, before you get there.
No problem.
In Lookner, the court noted, and I'm paraphrasing, but essentially they said, look, in cases where the accrual date starts upon notice, statutes have said so. The third statute does not. What's your response to that, and what is your best case to suggest that these particular facts are different?
Mm-hmm. Well, appellant's interpretation of that language is simply that where those courts have stated it, that is the rule. Now here, the absence of that language means that that is not the default. What the courts do instead is they look to what consists of the actual administrative proceedings to determine when the end exists. Now, that could be in some cases when the administrative decision is signed. It could be in others when it is filed. Here we have clear regulatory language that requires notice to the prisoner. And I think that is what's the distinction here, that under prison regulations here, there is clear language requiring notice. So whether or not it's in the statute, given that courts look to the applicable regulatory proceedings, that should be determinative here.
So if the regulation didn't require service of the decision, then your argument would be different?
Our argument would be different, Your Honor. I would note that here there is regulation, and to change it.
Why would it be different? So let's say the regulation just says the superintendent decides the appeal and that's the end. It doesn't say anything about mailing. And then, so she signs it and it sits there in the internal system for 60 days. You're saying that the inmate's out of luck?
Or to qualify my earlier statement, it's not that our outcome would be different. It's just the grounds on which it would be slightly different. Because in that case, in our view, that's essentially similar to Lookner, where there is ambiguity in the statute. Here, however, we don't even need to reach that question because the regulation is clear here. So in other words, that's why our argument would be different. Now, the policy and prudential reasons would counsel for counting from the issuance of notice, even in the case that you mentioned. So for example, in Boston Edison Company, the SJC noted long ago that this is a remedial statute, and remedial statutes are to be interpreted generously in order to achieve their aims. That's particularly relevant in prison disciplinary proceedings because of the impact that such disciplinary proceedings can have on prisoners, even when they're unlawful. These punishments would be suffered if there were no other opportunity to appeal from them if there were legal invalidities there. Prisoners also have limited access to the mail and to the legal system, absent some provision for notice. In fact, that's what motivated the prison mailbox rule in Rule 4D of the current rules of appellant procedure, and that the SJC and Supreme Court have recognized in Hartsgrove and Houston, respectively. And I think the rationales underlying those decisions are also particularly relevant here. In both of these situations, prisoners have limited access to knowledge of what the outcome of their cases will be, absent some provision for notice. In both contexts, the prison authorities control the access to information. So in light of that consideration, as well as the statutory framework and the other reasons discussed, appellant would ask this court to hold that Mr. Brooks's complaint was timely filed and then reverse the Superior Court's order of dismissal. If there are no further questions.
Now, I have one further question.
Okay.
That is, again, with respect to starting of the running of the search period. As I understand it, you're saying that the statute is ambiguous. The statute being the search statute is ambiguous, at least as applied in this context. Are there any cases that have contained that same holding? Any published cases from the appeals court or the SJC in any context that have held that the statute of limitations start date is ambiguous in that statute?
Well, I think part of it is that even if it's not stated explicitly, the analysis implies that the statute is ambiguous because courts have had to look to regulations in order to determine when the administrative action occurred. I also would note that on the text of the statute, the terms proceeding complained of are ambiguous. So I'm not sure that this court needs a clear precedent to observe that the implication from that language.
So it comes down to the interpretation of last administrative action then, right?
It comes down to the interpretation of proceeding complained of, which is currently interpreted to mean last administrative action.
Fair enough. Okay. Any further questions from the panel? No. Excellent argument. Thank you. We will now hear from Attorney Chavez.
Thank you, Your Honor. Good morning, and may it please the court. Amanda Shabs for the defendants. The lower court properly allowed the motion to dismiss, ruling that the plaintiff's complaint was untimely for these three reasons. The lower court appropriately relied on the holding of Lookner to rule that the critical event triggering the statute of limitations pursuant to Chapter 249, Section 4, occurred on the date the superintendent denied plaintiff's administrative appeal, which was February 1st, 2019, not the date of notice, which was February 4th, 2019. The lower court was correct in noting that the Lookner court rejected the argument that the 60-day statute of limitation should run from notice by noting that had the legislature intended to begin the relevant period from the actual receipt of the decision, that it could have easily done so as it is done in other statutes.
How does that make sense? How does that make sense, counsel? And how do you respond to the argument that the department could then shelve the decision for 60 days and serve it, and then the time for appealing has completely run?
Respectfully, Your Honor, the rules in the case and the statute is clear that the last administrative action is the date that the superintendent denied.
My question is, how does that make sense? And how do you respond to the argument that the department would then have unilaterally be able to shorten the limitations period by simply waiting to issue notice? How does that make sense?
That's not an issue here. That's not alleged. The facts don't support that. It's clear that what happened.
The support is that the 60-day time frame has been cut down by the issuance 3 days after the signature. So the timing has been shortened unilaterally. Do you agree that there is no limitation on when the decision issues? There's nothing to guide when the decision should be issued versus after signature?
I don't believe so, Your Honor. But the court did its the superintendent's office did its due diligence. What happened here, this was the decision that was made on a Friday, and the counsel and the inmate were notified on Monday.
What are the limits on the rule that you're asking us to adopt? So let's take a different hypothetical, and the superintendent signs a decision and then serves it 60 days later. When did the statute of limitations start running?
I think that would be a different scenario where, that would be akin to, equitable estoppel, where that was something was done.
It's a statute. I mean, it's not an equitable issue. The statute has to have a clear date. The statute of limitations has to have a clear date on which it is triggered. And I don't see any limiting principle on the rule that you're asking us to adopt. And maybe you can articulate.
Respectfully, I would say that it would be no different than a court issuing a ruling, an order for the Department of Correction to respond to a motion, for example, and say of the date of this order, but that we don't actually receive the court's order a few days. You go by the date that the judge decided. And
well, you go by the date typically of entry. And when you have entry, then lawyers are put on notice. They can go, they can look at the docket, they can check on their case. But in a prisoner situation, there's no other place for them to look. Isn't there information? They don't have, and there's no sort of, docketing system, I gather, where they could look to see the status of their case.
No, but they have access to the superintendent. They have access to the disciplinary officers to ask questions of. They're not completely insulated and don't have any recourse of asking, has my decision been made? Furthermore, the forms that are provided to the inmate, the form is very clear that what the date of the decision was, as seen on Record Appendix page 22. It specifically states the date of the decision.
And the notice of service is very specific that it was until February 4th. I mean, the purpose of the statute of limitations is so that a person doesn't sit on his rights when he's on notice that he's been harmed, or at least actual notice or constructive notice at a minimum. And if the decision's sitting in, the virtual equivalent of a desk drawer, I don't see how there could possibly even be constructive notice here. The inmate is obligated to call the superintendent's office every day to determine whether. So I don't really see what the limiting principle is here.
Respectfully, that's not the scenario here. That there's no allegation here that the DOC in any way attempted to insulate itself from judicial review or purposefully delayed notice.
But it could. It could, right? I mean, that's the problem.
Theoretically, yes, Your Honor, but I would respectfully argue that that would be a case for another day, that that's not what happened in this matter, nor has it been alleged that that's what happened in this matter.
I have a little different question, and that's, let me preface this by saying it is certainly not the role of this court to suggest or tell the executive how to run its business. So that is not the intent of this question. But at Record Appendix pages 20 to 23, as I look at the results of appeal, on every single page it lists the date. And I understand it's automatically plugged in. It's mentioned in your brief. It's automatically entered. But on every page it lists a date of I believe February 4th of 2019. And then on the final page it lists it twice. And then in one spot next to the signature, it lists February 1st. That strikes me as a little bit misleading. I can't tell the executive how to run its business, but should we be a little troubled by that?
Your Honor, I appreciate the court's
let's call it a concern and a question, and certainly no more than that.
I appreciate that. But within the same pages on Record Appendix 22, it's very clear. It clearly delineates the date of decision as February 1st. And also on Record Appendix page 23, it has the date next to the electronic signature of the superintendent, which is on the same date. The form simply is populated to have the February 4th date, which was the date that it was printed out, to be given to the inmate as well as counsel. But the forms are clear and do appropriately delineate what the date of the decision was.
So in this case, in effect, the appellant lost 3 out of the 60 days. What if instead this was, the date of decision was February 1st, but a copy had been served on February 25th?
That would be a similar question as Justice Shin's question.
Okay.
I apologize, Your Honor.
No, that's okay.
Presumably, it would still have to go by that date, the date of the decision. And we specify that the statute, the cert statute, is clear, does not qualify for notice or the date of decision. And the other courts have indicated that in prison disciplinary proceedings have noted that the final administrative action is the date that the superintendent takes action upon the appeal.
Why wouldn't the final action be the date that it's issued? That's the final, that truly is the final thing that's done, issuing the decision to the prisoner.
I would argue that that is simply a procedural mechanism. It's not the last administrative action of the administrative agency making the decision.
It's not an administrative action?
I'm sorry, Your Honor?
It's not an administrative action. It's indicated that that's required as part of this proceeding to notify the prisoner.
I understand that the CMR on the effective date has that. And I would point that the language of the CMR in 2018 for the purposes of this case was very similar to the language that was looked at in this court's 128 decision in Cruz v. Spencer, as well as in the Pidge decision. In Cruz, the court discussed the statutory construction of 249 section 4 with the DOC regulation regarding the appellate procedures for disciplinary proceedings, which has almost the exact same language as the 2018 CMR, and ruled that the last administrative action is the date of the appeal decision. And Cruz relied heavily on the Pidge decision, which there were 2 issues in that case, one of which was the same as here with respect to the statute of limitations for a prison disciplinary proceeding. And the CMR in that year, which was 1987, was also very similar in terms of having notice. But the courts have indicated that that is not the last administrative action, that the last administrative action means the final decision of the agency. And that's why the date of the decision of February 1st in this matter is controlling.
Those cases, correct me if I'm wrong. Sorry, I'm getting some reverb here. Correct me if I'm wrong, but those decisions did not have anything to do with whether the accrual date is the date of signing or the date of service. Is that accurate?
Cruz did, Your Honor. It specifically looked at the CMR and indicated that the regulation described no administrative action or administrative step beyond it. And then it went on to say, quote, thus the final administrative action of the plaintiff's disciplinary proceeding occurred on, that gives the date, when the facility superintendent denied plaintiff's disciplinary.
But that begs the question. I mean, it's not, the question there was not whether when the date that the superintendent denies the appeal could be either the date she signs it or the date she issues notice. And that case did not resolve that question.
Cruz did not specifically ask that question, no, Your Honor. And it didn't note the date that notice was provided. We do know from the facts that it had to have been provided within 5 days of the date of the decision, because the inmate had filed a grievance about the proceedings and wasn't acted upon because disciplinary proceedings are not grievable. But the courts, particularly in Lookner, was very clear that the court ruled that the last administrative action was the date of the decision. It notes the decision date as 2/28/96. It notes what the date of notice and receipt of notice was as a separate date. They indicated that both of those dates was March 4th, 1996. And in its analysis, it indicated that the controlling date was the date of decision, and it does that twice. On page 836, it does it, and on page 837, it specifically identifies the date of decision of 2/28/96 as being the critical event that triggers the mechanism or the action of the operative conclusion of the proceeding complained of. And it notes that that was the date that the decision was made.
But Lookner also did not address the question of what it means, what date controls issuance of the decision, whether it's when it's served or when it's signed. I mean, I guess the fundamental problem I'm having with your position isn't the concept of notice just integral to a statute of limitations?
Your Honor, no, and I would simply rely on that if the legislature wanted that notice to be an operative date for the statute of limitations, that it would have indicated so.
It's so integral to the concept of a limitations period. I don't see the missing word notice in the statute to be all that relevant, to be honest. And the certiorari statute encompasses a very broad range of administrative actions. Sometimes there are decisions issued, written decisions, sometimes there aren't. So it's context specific, but it's just hard for me to reconcile your position with what I consider to be the purpose of the statute of limitations.
And Your Honor, I would point to the Chapter 30A, which was cited by the Lookner Court in discussing the cert action, that those cases that their administrative proceedings fall under that chapter, that's a certiorari review, and that statute is very clear.
Because the 30A requires issuance of a written decision, right? Whereas a certiorari statute, certiorari action can be brought to challenge a different kind of administrative action. Anyway, I know your time is up. I don't mean to belabor the point.
Are there any further questions from the panel? Seeing none, thank you both for your. Okay, calling our next case. Are we live? Not yet.
One moment, sorry, it's still loading.
Oh, my bad.
And we are back live and on the record.
Calling our next case, docket 2019 P1824, Federal Square Properties versus DeRusha. And we will hear first from counsel for the appellant. I believe that's Attorney Duffy.
Good morning. I'm James Duffy, and I'm here on behalf of the appellants. May it please the court. This appeal is brought by Federal Square Properties and arises out of a Commission Against Discrimination decision that was wrongly decided at the outset. And those errors were compounded by the further significant administrative delays by the Commission in making its final determination. This has had the effect of doubling the penalty that Federal Square Properties faces and has created an impermissible punitive award that shocks any sense of justice. The Commission's more than 6-year delay between the determination made by the hearing officer and the final decision, which frankly was largely a rubber stamp of that decision, has resulted in a decision that was inequitable, arbitrary, and capricious. Even granting all due deference to the agency, the reviewing court must still determine whether an agency's decision is supported by the substantial evidence upon consideration of the entire record. And in this case, it simply wasn't. The subsequent award of interest and to both the emotional distress damages and the award of attorney's fees has now created an award that has no connection or bearing with the actual claim or harms claimed.
Attorney Duffy, can we start?
Federal Square.
I'm sorry to
Yes.
interrupt. Can we start with what's appropriately before us, or what is before us right now? And it seems to me that the notice of appeal to the full commission is at record appendix page 64. Is that correct?
I believe you are correct.
And I understand it does not appear that you are, at least you're not listed as counsel on that, but nonetheless, the notice of appeal says on the very first line, Federal Square Properties and Pacific Land LLC are appealing only the civil penalties rendered in this case. So how is it that the emotional distress and other issues are properly before us?
Well, I think there are two aspects to that. Now, in our brief, we note that Federal Square Properties was not represented at that time, and it did raise the issues of Ms. DeRusha's testimony and the lack of evidence for emotional harm at that point. And it understood that the doing so in the post-hearing brief preserved its appellate record. I would also note that the issue of emotional distress damages was in fact raised by the complainant and addressed by the full commission. But even if the court does not accept our position, it does not negate the appeal we have made with respect to those decisions that were made after the initial hearing, including the awarding of interest. That was solely made by the full commission, and that is quite frankly what turned this into a bad decision into a punitive one.
Do you want to go forward and explain how is this scenario that you're in any different from any? There's delays in all kinds of proceedings, and it's just sort of an unfortunate consequence for everyone involved that a proceeding might take longer than others, and as a result, there's going to be interest. How is your situation unique?
Well, as identified in, I believe it's the brief for Ms. DeRusha, interest in a court proceeding is governed by General Law Chapter 231. And that is specifically set out by the legislature. It is known by the parties at the outset that any award of interest is going to be applied to this case. The commission does not have the same ambit. It's charged with fashioning an equitable remedy for the purpose of protecting the public and eradicating systemic discrimination, but there's no specific charge for applying interest to any decision. Further, its ambit is bounded by decisions by the Supreme Judicial Court that it cannot cannot award emotional distress damages for punitive purposes. That simply finding a instance of discrimination is not sufficient to permit an inference of emotional harm. So taken all together, it is the responsibility of the commission to review the facts before it, to review the totality of the circumstances, and that includes both the facts as they were determined by the hearing officer and any issues that occurred outside of that, including administrative delays that were not caused or had any bearing on the decisions made by the complainant or the respondent in these cases.
Well, I mean, the delay isn't attributable to her either, right? So So should she be penalized by the delay by not awarding interest?
Well, she, in this case, would not receive, she is not suffering any harm or due
Well,
to
it's
a
the
delay
harm-
that
it's
is
the harm of
not her.
The harm of not having that money for 6 years. And here's another issue I'm having. I think, as Justice Nyman pointed out, the notice of appeal is pretty clear that it is appealing only the penalties. So at that point, when you filed that notice, well, not you personally, when your client filed the notice of appeal, they knew that at that point they were liable at least for the damages to Ms. Darusha. Right? So, I mean, they're not appealing that. So it seems to me, at least at that point, they should have tendered the payment of $500, okay, first. As far as the attorney's fees, the fee petition was filed in 2012. The statute mandates attorney's fees. So your clients knew at that time that they would be liable for some award of attorney's fees. Even if they were contesting the amount, could they not have tendered payment under protest and then challenge the amount of fees later?
Well, if they paid any amount, I think the concern would be that would moot the entire appeal and prevent them from essentially making any argument before.
No, because the penalties are not being paid to her. Right, so your clients appeal the penalties. They don't appeal the $500 damages award to her. So your clients could have paid the $500 to her and still appealed the penalties.
I think at that point, they did not expect that there would be a 6-year-long delay between the initial hearing and the final determination. And
all right, but in year 2, they still don't have a decision. I think the reasonable thing to do would just be to pay the $500. I think the attorney's fees is a trickier question because your clients challenged the amount that was requested in the petition. But could you not have paid that under protest?
Yes, they could have paid that under protest, but that doesn't get to the fact that they neither knew the amount of the attorney's fees that were going to be assessed, nor had a reasonable way of determining what the ultimate interest on those attorney's fees would be. At that point, there wasn't any reason to believe that an interest was going to be applied, or that it would be applied for 6 years from the date of the motion for attorney's fees and the date of the final determination by the commission.
Isn't interest awarded as a matter of course in these cases?
There is no statutory requirement that interest be mandated or be awarded in these cases. There isn't a comparable
right, but
statute
as a matter of administrative practice, isn't it routine?
Again, I would just say that while the commission has the right to craft the penalty as in a manner that is equitable and protects the public with the purpose of eradicating systemic discrimination, and the determination in this case simply does not do that. Whether or not it could award interest in cases does not necessarily mandate that it will award interest in cases.
Going back to your initial argument, which is that your client should not be responsible for the multi-year delay and have to pay that much interest, is there any authority for that proposition?
Turning to the decision in school committee versus Commission Against Discrimination. In that case, the court found that the complainant, or the respondent, was liable for interest. However, in that case, the determination was based on the fact that they had litigated every single facet of that case, and that they were ultimately the party that was responsible for the delay. Here, there can't be any justification that Federal Square Properties was the sole party responsible for the delay. As this panel has pointed out, they appealed a single discrete issue. Also, Ms. DeRusha appealed. I'm sorry?
I'm sorry, the school committee case held that the doctrine of latches did not apply.
Correct, and ultimately that they were responsible for the associated interest in delays. I think here we have.
I didn't realize that you were framing this as a latches argument.
But I think in this case, where Ms. DeRusha is also liable for the delay, she should not then get the benefit of those full 6 years of interest.
I'm sorry, how is she liable for the delay? In what sense?
She as liable as Federal Square Properties due to the fact that she also appealed a portion of the decision.
But you're not really,
Uh,
your position isn't that either party was responsible for the delay. Your position is that it was the agency.
Correct.
So why do we even look to the responsibility of the parties? Is there any authority for agency processing delay to have an impact on whether there's interest?
I did not find anything that applied or anything from Massachusetts. However, there were cases that were on point dealing with similar complaints from other jurisdictions, including the EEOC and similarly situated commissions. And here it is an equitable argument that where the appellant in this case did not control or could not control the delays caused by could not control the administrative delays, it should not now be responsible for that additional $13,000 penalty from the date that the commission selected in 2012 to its final determination in 2018.
You're arguing that because the award of interest is in the commission's discretion, that when there's a delay that's this long, that should be taken into account, as well as the fact that the other party also appealed.
Correct. I think the commission should view the totality of the circumstances when it's fashioning its equitable remedies. And that includes any administrative delays that are due to staffing issues on the part of the commission. That would also include the fact that the other party has appealed.
Let's assume that she didn't appeal anything, and otherwise the facts are the same as a 6-year delay. Would then the MCAD be outside its discretion to award the full amount of interest?
I think in that case, that's a very different set of facts and circumstances. In that case, the party that appealed was solely responsible for that delay. And in that case, I think that it would be within the commission's discretion, depending on the facts and circumstances, to apply interest as would create an equitable decision.
Mr. Duffy, I've seen your time has run out. If there is any part of your argument you did not have the opportunity to get to, I could give you another minute if you would like.
I appreciate that. I will rest on my briefs.
Excellent. Thank you very much. We will now hear for counsel for the appellees. I should have asked, do you intend to divide your time? And if so, what is the division?
We are not dividing our time, Your Honor.
Okay.
May it please the court, Lynn Milanazzo Gaudet for the Commonwealth of Massachusetts Commission Against Discrimination. With me here today is Attorney Shack for Melissa DeRusha. With that, Your Honor, this matter is before the court on 30A review. As such, the review is confined to the administrative record and to those issues properly preserved through the administrative judicial process. It's the Commission's position that appellant's objections to the award of emotional distress and to the assessment of the civil penalties have been waived, leaving only the objection to the award of the interest to the attorney's fees before this court.
I asked you about the civil penalties. It seems to me you're taking a pretty strict interpretation of waiver. The 30A complaint specifically mentions the penalties, and then the motion for judgment of the pleadings argues liability. So why isn't that enough to preserve it?
Well, Your Honor, I would suggest that when the 12C motion was filed with the court for judicial review, the appellants in this case did not raise the civil penalty. They argued liability. So, I mean, if there's no liability, then they're not liable for the penalties. So it just seems to me to be very, it's an overly strict reading of waiver to say that just because they didn't specifically say penalties in the motion, that it's waived. Well, I would suggest that if we then look back at what was actually appealed to the full commission here, that the only issue before the full commission was in fact the civil penalty, and it wasn't the issue of liability and the underlying liability in the case. And in appealing the civil penalty to the full commission, it wasn't the fact that the civil penalty was actually assessed, but was only the amount of the civil penalty that was assessed. So it was a request to reduce that civil penalty. Now, when was appealed to the Superior Court on the 12C, the civil penalty wasn't raised. This was an objection that was made during argument. And in raising it in that type of forum without briefing the matter, similar to something before the appellate court, it doesn't properly reserve it. Additionally, there is a finality that is expected in these situations, in that if something isn't properly argued and then something is presented, that it doesn't give the administrative agency the finality that it needs in these cases.
So you just said a moment ago that the civil penalty was not raised before the court. Did you mean the emotional distress?
The civil penalty was not included in the 12C motion for judgment on the pleadings before the Superior Court. So relying on the Albert versus Municipal Court of Boston case by the SJC 388 Mass 491, which speaks of raising of issues before the administrative agency as waiver, but also the fact that a party is not entitled to review of an issue not presented in the court below, I would suggest that it's not properly before the court here.
So I have a question for you that requires you to assume that the negligent infliction of emotional distress is properly preserved, okay? So with that in mind, your brother in his brief lists the elements of negligent infliction of emotional distress, and among them he says it requires proof of, quote, physical harm manifested by objective symptomology. Do you agree that that is an element, or was an element here, that was required to be proved to the MCAD?
Well, Your Honor, I would say the following is that in order to determine emotional distress under 151B, the analysis does not mirror that of a negligent infliction of emotional distress claim. That in fact, the SJC in Stonehill College gave us guideposts for which to follow in determining whether or not there is emotional distress. And what that is the nature, severity, duration of the harm, and whether or not mitigation occurred. And here, the hearing officer did find, in fact, that there was emotional distress in the anger, frustration, the anxiousness, the agitation, and the feeling of being unfairly judged.
So to go back to my question, is physical harm manifested by objective symptomology an element that was required to be proved, or are you saying no?
Answering more clearly, I would say no, Your Honor, that it is not an element of emotional distress under 151B.
And the Stonehill College case is your best case for that proposition?
Absolutely, Your Honor. And here, in determining emotional distress, it is the hearing officer who hears the testimony as the trier of fact and watches the individual as they testify, who makes a determination as to what the emotional distress should be. Here, the hearing officer did that and, in fact, awarded only $500 in emotional distress based on the credited testimony. Now, if I may, moving to the accrual of interest in this case, it's the commission's position that that is the only issue that is before this court properly. And there are 2 points that I'd like to advance on this issue. The first is the reason for the interest in these cases, and that goes to the public interest. And the second is the mitigated harm, similar to what Judge Shin was asking about. From a public interest perspective, it's the ability to fully compensate attorneys that bring cases before the commission, which is very important in order for the commission to satisfy its legislative mandate. We've been mandated to eliminate discrimination and, among other ways, the investigation, prosecution, and adjudication of discrimination. As recognized by the SJC in Fontaine versus Ebtech, 415 Mass 309, the statutory provision for the attorney's fees aims to attract competent counsel in order to litigate these meritorious claims. It's important to provide an incentive for these attorneys to represent complainants before the commission to vindicate rights whose claims may not have a substantial monetary compensation. And that's especially true in housing cases where damages awards are often low, but by the fact that the complainants have to mitigate their harm in order to end up.
So the award of fees is mandatory and it serves those purposes, but interest is in the discretion of the commission. And here it took 6 years to issue a nine-page decision. Is that a typical amount of delay?
There is no typical amount of delay, Your Honor.
Well, would you say that's unusual or is that commonplace?
I would say the following, Your Honor, that the commission has been an underfunded agency for quite some time. However, and we have had a backlog.
So
however,
it's not unusual.
It's not unusual, but it's changing. It's changing.
So let me just ask this. So let's say, I mean, the parties have a right to appeal to the commission, right? Let's say you have an appeal, a really close case, and the appeal is potentially meritorious, and the respondents appeal, and it takes 6 years, and they ultimately lose. And let's say the complainant also appeals, just like she did in this case. Is it the commission's position that they can't take those factors into account in determining what amount of interest is appropriate?
The commission has wide discretion to fashion a remedy in order to
right. So they can take it into account, right? And here, it looks like in at least what happened here, and maybe in practice, they don't do that. They just mechanically apply the interest rate based on the number of years.
Your Honor, I would say that there is no mechanical application. And here in the facts of the case, while there was an opposition to community legal aid's fee petition of $16,300 plus costs of $95, the only thing that was appealed were certain sums which Federal Square said were unnecessary, excessive, or duplicative. And in looking at the record at page 26, the full commission notes that the only thing that's being challenged was $1,200 in this case. So had Federal Square opted to mitigate their harm by paying the 93% of the interests of the fees and costs, that 93% of the fees and costs would not have incurred any interest in this case. And they would have essentially mitigated their.
So let me ask you again about the hypothetical. So you have a very close case. The respondents appeal. It takes years for the decision to issue and they ultimately lose, but the commission acknowledges that they had meritorious issues to present. Would the commission take that into account in deciding the interest award or not?
Well, understanding that I can't answer that hypothetical specifically in that I have not seen that case come up before the commission where there has been a need to reduce the interest. In considering the interest on attorney's fees, though, again, reverting back to the public interest in having attorneys take these cases and considering the time value of the dollar, that the only way that an attorney's fee is going to retain its value is with the compensation through the interest award. And if we do not include the interest in these fees as a practical matter, the reduction in the fees is antithetical to the end purpose here, which is getting these attorneys to take these cases.
So are you saying that because of that view, even though you have the discretion to do something different with respect to interest, you would not do that because you don't want to disincentivize lawyers from taking these cases?
I would answer that, Your Honor, by saying that the commission looks at each case individually and makes a determination how best to proceed under the circumstances of that case. There is no hard, fast rule. And the court and the commission would act within its discretion to make an award accordingly.
So there are commission decisions where the commission hasn't awarded the full amount of interest based on equitable considerations?
I'm not aware of a case where the interest has not been awarded in full. However, I can think of circumstances where, through similar to your hypotheticals, that maybe the commission would consider not doing so.
But in practice, it hasn't happened, right? And it seems to me it wouldn't undermine the purposes that you mentioned. It wouldn't undermine those purposes if the commission were still to take into account, the equities that are presented in each individual case, right? I mean, because you could have a very close case.
And yes, Your Honor, and it would not undermine it. And the commission does consider its discretion and exercise its discretion as necessary in order.
But it hasn't. I mean, you just said there isn't a decision that we can look to where they've considered it as a matter of equity.
Well, I would suggest that although they haven't, that doesn't mean that they wouldn't.
Okay.
And you're saying this case, it was not necessary in that at any time, Federal Square certainly could have mitigated their own harm by paying the 93% of the attorney's fees that were not being challenged in this case. I would say also, well,
I'm sorry, what do you mean by that? They weren't challenging 93% of the fees?
The objection to the fees that were filed by Federal Square was only an objection to approximately $1,000 of that fee award.
No, they're saying it. I'm reading from the commission's decision. It says respondents have filed an opposition arguing that the amount sought should be reduced to $1,222.
I'm sorry, Your Honor, I had read that they were only challenging $1,022 of that was my reading of the decision.
The amount sought should be reduced to $1,222. So they're challenging about $15,000 of their.
Okay, then my math is wrong, Your Honor, and I apologize for that.
What should they do? Should they pay it under protest?
That is always an option. They could pay it under protest.
And if they do, then the complainant's required to pay it back if the commission determines that the amount is excessive?
I would suggest that that is something that could have occurred. But I would also say, Your Honor, that Federal Square was under an obligation that they should have known the forum with which they were defending, that they could have merely looked at full commission decisions where and known how much time it would take to fully litigate a case through the commission, and the likelihood that a well-documented and reasonable fee petition would have been upheld under the lodestar method used by the commission in awarding attorney's fees. Now I see that my time has expired. Are there any other questions? Then the commission will rest on its brief. Thank you.
Thank you.
Case is regarding a harassment order. The harassment order was heard in East Brookfield, where I was present and my mother was present. At the time of the harassment order, I presented my case, and I get a copy of her testimony where I was attempting to defend. During that time, I attempted to present my evidence. I was not able to do so, where I was attempting to show that my vehicle was wrapped and that she could not identify the vehicle. I presented that as evidence. Her own testimony herself, she testified that she was not sure it was my vehicle. From my research of a harassment order, she needs to identify 3 willful or malicious attempts to cause fear of serious bodily harm, intimidation, sexual assault. I don't feel that she demonstrated any of those. My own admission, I did attempt to call her one time. That call was played on record. That call was not to cause intimidant fear of serious bodily harm, intimidation of fear. It was to identify that her public record was released, that I did not feel that it was appropriate that it was released, and to basically inform her that her information was released and to hopefully engage her to take proper precautions to get that record sealed. It wasn't a first act. I feel that the justice that was listening to the case violated social right acts, because a social worker that is representing me released information to the person in question as far as testimony. That information should have been privileged. I have a right to report, and the information that was released was my right to report. Granted, she might not necessarily like that I am reporting safety acts regarding my children, but that is my legal right. So I don't know how that can be held against me legally as a decision right to order a harassment order.
Are you, excuse me?
Yes, Your Honor.
When you're talking about that right being violated, that you were making certain complaints against the other party, but that, are you saying that your identity should have been withheld, that it should not have been reported to the other party, that you were the one who was making the complaints?
Correct. So my understanding is, unless you're a mandated reporter, all these complaints are supposed to be anonymous. That's to protect both parties. That way there's no retaliation. And the only time I'm filing is when I feel there is a substantial concern regarding the safety and well-being of my child. Her own testimony during that trial is that, from what was reported to her, is that she stated that if she was in my shoes, she would have filed as well. So I feel that the justice hearing the case used that against me, and I don't feel that's necessarily right, Your Honor.
Sir, was it your, I want to make sure that I read the transcript correctly, but was it your testimony that the only communication you had with the other party was that initial telephone call?
That is correct, Your Honor. I called her one time regarding that initial telephone call. DCF at that time felt extremely against that. They harassed me numerous times and served me with a formal paper notice of like a harassment order. I don't think it was legal, but that's not my say to get into that. Where DCF and the plaintiff at the time in their own testimony said that I never violated. So why they've gone a step further to drag me into court when their paper order that they served me with, I never violated, I'm not too sure. What I did see in court is on top of her normal affidavit, she resubmitted a second affidavit where I was not able to take the time to defend myself.
Was the second affidavit at a separate hearing? Is that what you're referring to?
No, DCF handed her a list of information about me regarding my transactions with filing, talking to the department regarding my safety concerns. And she presented that as a second affidavit and used that as testimony against me. In my testimony, I was able to review the document very briefly, and I stated I didn't have a chance to defend myself. And the justice at the time said, unfortunately, I'm accepting this. And I felt that I had a right to defend myself and wasn't afforded that right, Your Honor.
So, sorry, this Justice Shen, by coincidence, the order, I believe, expires today. Has the plaintiff sought an extension?
I honestly am not aware, Your Honor. I know the courts and even this court is having a hard time serving her, which I don't understand why, because she has reported to the lower courts on numerous times. She still resides at that address.
But you haven't received any notice to come in for an extension hearing?
No, I have not, Your Honor.
Thank you.
So it's my personal opinion and assumption is this is a plot by DCF for the lower court's trial hearing. I think if they feel that this order is weighed over my head, they have a better chance in the lower court of removal of the child. And I feel strongly of that reason because she states in the lower court that's the address she wants to be served at, yet she is refusing service, which I don't understand. And like I said, it's an assumption. There might be other technicalities that are involving into this play, but I honestly don't know.
Sir, I'm a little confused. You say she's refusing service of what?
What was reported to me during my filing of this appeal that she was served multiple attempts of notice at the address that she provided to the lower courts to file an appellant brief and to be present during this testimony. I was informed electronically that and verbally, because I've also called in numerous times and spoke to the clerks, that they have not been successful at serving her.
Okay, thank you.
Yes, Your Honor. So I know me appealing this, I know this really doesn't affect me as far as the lifestyle change. It's just a moral technicality for me that I don't agree with. As far as my day-to-day lifestyle, it doesn't affect me. So I feel if it didn't get overturned, it wouldn't really affect me as life, but I have been brought up in a moral obligation. Treat people the way you want to be respected is how I was brought up. And I don't feel that I was afforded the opportunity to defend myself. And when I attempted to display my evidence, and I came in well prepared, and I brought all the evidence that is in front of you today, the day of the original hearing. And I was not I wasn't afforded a time to display my evidence. And I feel that that was strongly not allowed because the department themselves came in to that hearing and testified. So I feel that if the department wasn't there, I might have been forwarded that right, but I honestly don't know if I would have. And that's what I have an issue with today.
So I want to make sure that I understand, when you say you weren't given an opportunity to really present your case, I want to make sure I know what you're talking about specifically. One is you said that that the plaintiff had a document that you only got a short time to take a look at.
That is correct, Your Honor. And in her own testimony, she stated she had cameras installed on her house, and that the justice at the time asked her how she knew it was me, and she stated that it was through the cameras. I was able to present my case, and during that I stated, well, if she has these cameras, there's numerous vehicles out there that match my description. How can you physically for 100% identify my vehicle? And I also stated to the justice at the time this supposed action occurred, my vehicle was wrapped in a corporate logo 100%. And that's, if she truly knew that, she would have been able to identify that. And I presented that as evidence. And I was attempting to present it as evidence then, and I presented it as evidence now. My vehicle was fully wrapped in an American Express logo. So yes, the vehicle shape, size, and all that is the same, but the characteristics of the outside is totally different. And in her own admission, she stated she couldn't prove that it was me. So I don't think she met the minimum standards for the harassment order, in my personal opinion, Your Honor.
So as I understand it, you're not saying that the judge said, no, you can't discuss that, or no, you can't introduce that evidence. You're saying that you just feel the overall proceedings were not fair and that she did not sustain her burden of proof. Is that a fair summary?
Your Honor, I actually asked to present the evidence, and she stated I couldn't.
What evidence did you seek to present that you couldn't?
The pictures that you have of the vehicle wrapped, I attempted to present that as evidence.
Is that in the transcript?
It should be, yes, Your Honor.
Okay, anything else?
I also attempted to present a medical document where one of the dates and actions, I was actually hospitalized because I had a heart attack due to a vasospasm. So one of the incidents I could not have done of what she reported due to being hospitalized, and I was not able to present that evidence as well.
Thank you.
Yes, Your Honor.
Anything else?
No.
Okay. Well, let me just check with the panel. Any further questions from either justice? Seeing none, I have none as well. Sir, we thank you